Williams. Is it hurtful? I'm not the one wasting time. I'm here every day, ready to go. I am not wasting the time. I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And it has to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever on these occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I have a responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated.
And then you won't apologize. And I did nothing wrong ever on these occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I have the responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated, and that's that's the crucible and trial of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared, but the things that I am bringing up to both of you, and I have fussed at both sides for this particular issue of not being prepared in the sense of, and the only reason it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken out. And sometimes if we've got to parse out all these things, as you can see right now, it takes time, and that's what I'm kind of concerned about, having been a jurist for a long time. So I understand that you're a zealous advocate. You in no way offend me by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the courts told you, and I certainly could have explored other options. I didn't. So I'll tell you that much for what it's worth.
You allowed a member of the bar yesterday ask a witness who constantly is committing, respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and sir,
I would have said that question about another member of the bar, prosecution. You would have come over the bench and said, "How dare you?" I sat there and I said, "Outrageous! You denied the motion." I think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you, the appearance, if not the reality, is not good here. I'm being...
What, to who?
To Mr. Williams.
Okay, but...
Maybe to the other. Maybe
you're his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that. They have the right to at least inquire about whether or not that happened. Now, whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motives to misrepresent.
So that never happened. No good
okay,
faith.
but I'm not commenting on that. That's for the jury. That's for the jury to decide.
I asked a question about a missing recording that wasn't given of a statement made by Mr. Bean. And you told me.
And I keep telling you.
You told me. You said, does the state have it? They said no. You said nothing I can do. I tried to cross on it. You sustained an objection.
Because it doesn't exist at this point in time. Now, if it exists at some point, I told you I'd say it. One, I tell you, I apologize to you. And then two, I'll take corrective action against the party or the entity that failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective.
But we don't. That's the only is. You believe it. You honestly believe it, and that's true.
On September 17th, 2013, I'm recording. Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall. I don't remember anything.
Here's the thing. That's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything, but if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm speaking with the court.
Your Honor, I object.
I'm speaking with the court.
Okay.
I'm speaking
with
the court.
Let him finish, and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens
but
of
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that is
certainly to do with the throw of war.
No, I mean, it's your ability as an advocate. I told you before, that's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that, my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without.
I think I've taken Ms. Love and Ms. Hilton and her colleagues to task many times.
No, I've heard you yell.
I've taken them to task as well.
I've heard you say to her, "Stop interrupting me."
That's taking them to task.
The jurors never heard that. Ever. So I ask for a continuing recusal motion. I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, when you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do, and I'll appropriate.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now,
I don't think it's a fair forum for Mr. Williams. Okay. And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through I've told you all, both sides have told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Well, I made this motion whenever I made it, and I raised it, and you said we'll get to it.
Yeah, but it's timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it so I could kind of take it at that point in time? None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right. Okay. All right. Ms. Lowe?
Your Honor, just the state would ask that the court deny the motion for mistrial. The state has provided to the defense these jail calls. We have actually requested more than once what portions are objectionable, what portions do they not want us to play. We have sent them to the defense in a format that they can listen to them offline without having to have the actual CD in. We have had them converted for them. The objection that we got initially was put to the call that Mr. Steele essentially put in by playing the recording of the interview that Detective Quinn did with Adrian B. And the whole jail recording that was played during that interview was State's Exhibit 175 Charlie Alpha. So the portion that they initially said that they objected to, that third party portion, and we had a motion on it, they actually introduced by playing the call, the interview with Detective Quinn. I have said to them, I'm certain that Ms. Hilton has communicated with them via email that we are using the jail calls. And I know I personally have asked, what do you object to? So at this point, I'm not certain why there is this motion. I object to the language that is used. I'll die if the court does this. Your Honor, the court is well aware of the times that the state has received reprimand, both in front of and out of the presence of the jury. I'm not certain where that's coming from. I would ask that the court, of course, the court has already ruled, but the notion that there is a bias, I'm not certain even where that's coming from, given the amount of tongue lashings we've received from the court on the state side. So I would just object to the defendant being granted a mistrial. And I state for the record that the portion that they identified for us that they objected to regarding the jail calls was entered through their cross-examination of the witness, Adrian B. Thank you.
What about the sealed document? Mr. Steele is raised or made an issue at this point.
With relation to the sealed document, that was a memorandum of the interaction that a lieutenant with the district attorney's office had with a party as it relates to Mr. Steele's interaction with that party, unsolicited, after walking out from the stand. That party made comments to members of the district attorney's office. The state asked that party, and we did not assume facts that were not in evidence. We asked, unlike the question, why did you do this? Or why did you do that? Which would assume facts that were not in evidence. We asked the open-ended question with a good faith basis for doing so, and with an ability to impeach if there was a denial of having said it. So we didn't make that up out of whole cloth. We wanted to make certain that all parties on the defense side had that random. And frankly, Your Honor, I think it is improper for anyone, for certainly any member of the bar, to stand up during the cross-examination, direct examination, and offer testimony essentially to a jury. So for Mr. Steele to stand up in the middle of my redirect of Adrian B. and to say that did not occur, or preposterous or outlandish, is completely improper, disrespectful. The state has done nothing of the sort, and we would ask that Mr. Steele be reprimanded for doing so, and the court rightly did so. And to have him ask for an apology after he has been blatantly improperly acting before the jury, I don't know what else I could say. I would just ask that the court admonish counsel for testifying during trial. I have given the court the basis for the questions that I asked. I never asked the question that assumes facts that are not in evidence. Unlike the question, why did you know that? Do you recall that? I didn't phrase my questions like that because I know not to do that. And I'm not going to do that. And I don't want to improperly give the jury an impression of something that exists or that will be shown that I can't show them. So there is a real clear distinction in what Mr. Steele asked, implying, why did you give a statement at the hospital? And he keeps conflating what it is that is objectionable. He keeps asserting something so that everybody in the ethos is asking, oh, where is this interview? Where's this recording? He's never seen one. He doesn't have a good faith basis asking for one. And yet he continues to put that question out there so that everyone in the universe has this idea, oh, the state is hiding something. Oh, the state destroyed evidence. Again, they sat there for a whole day asking witnesses about the destruction of evidence. There's no evidence that anybody destroyed any evidence, yet they stood there a whole day and asked someone about that. And then he asks a witness on the stand under the guise of impeaching him, do you recall that? Or didn't this happen? Or can you explain why the state would delete, or can you explain why the state failed to record your interview at the hospital? And he has no information that an interview at the hospital exists. So all of that, Your Honor, I don't know if Mr. Steele wants, to give an impression. I don't know. He's vigorously advocating for his client. That's what he is supposed to do. But I would ask that the court deny all of his motions. They are baseless. And I would ask, I've taken my licks from the court. We all have. And I'd ask that the court deny the motion for recusal. The court has made rulings that obviously the state hasn't agreed with. The court has made rulings that other people haven't agreed with. So this notion that somehow the court is biased, when as recently as a few days ago, I caught it hardest. It was played everywhere. I'd ask that the court just deny Mr. Steele's motions, all of them, out of hand.
All right. Ms. Hilton, do you have any explanation as to why this third call was just disclosed today? Is that true? Is Mr. Steele correct?
No, he is not, Your Honor. These calls have been turned over. As a matter of fact, I'm getting ready to send an email forward an email to defense counsel that shows when they asked us to have the calls converted because they could not hear it on a CD, they asked us to have these calls converted. Literally on January 5th, and I'm actually in the process of forwarding these calls. Mr. Smith sent these calls on January 5th, all of them. I believe a few weeks ago, this is the email that I'm looking for, when this case was first going to happen, probably in December, when we were to disclose to defense counsel what media we were going to use. I believe in one of those emails, and that is what I am looking for, I told defense counsel we're going to use all of the jail recordings. So this is not a surprise to them that we're using the jail calls. The only call that has ever been objected to is the first call that was played yesterday. They have not made an objection to any call. They just want to know which of the 8 calls this is. The state has no problem to do that. But to say that they just received the calls or they just learned about the calls, that is not true. They've known about the calls. Now, for me to identify this last call, I can do that. And I'm going to look for the email, or it might have been conversation in court. But when they asked, what media will you use? I think I said, we're going to use all the jail calls. And we're not actually using all the jail calls. We're going to use 5 of them. So this is not new evidence for defense counsel.
Sir.
About and maybe this will give a path moving forward that's a little bit more efficient, hopefully. There are thousands of jail calls in this case. So,
Your Honor, hold on. Not for this case, but Acts 5 to 7 specifically.
Okay. There are thousands of jail calls for this case. So they gave about 10, 12, however many jail calls. They're saying, I'm not going to dispute that. I don't have my computer in front of me. But it seems very inefficient to me that we're going to litigate, and you want us, the defense, to raise our objections to thousands or even 12 jail calls and suggest redactions for all these jail calls.
But when did you get the jail calls? When did they tell you? Didn't they tell you like within a week or two,
So-
like I asked before,
so-
that they were going to use these calls?
So, Your Honor, they just identified one is the chicken call. That's not how they are in discovery. So there's a cross-reference number. So we need to know exactly what call by the cross-reference number in discovery. There's nothing labeled
Yeah, but
chicken call. There's nothing.
All right, but listen, is there a certain number of calls for this particular act or acts? I mean, yes or no?
I can't, I don't have the email in front of me. So,
Yes, okay, so there's how many? 8, 10 calls? How many?
Your Honor, there's actually 8 calls and 2 of them were duplicates. And so in the
Okay,
email
so-
that I broke down.
So in preparation, you know that if you get this particular act, which we've been dealing with for weeks, you only have about 12 calls to listen to, right?
So, yes, so you would like us to proactively state our objections for every call and litigate, because they're not using every call.
Only if it becomes an issue, because if you all work it out, that's fine. I don't have any issue with that. But if it's going to be an issue, then I need to be able to vet it. I got to listen to the call. I got to listen to the evidentiary basis as to why it should be admitted or not admitted. That just gives me time to do that. And if you say it's only going to take about 15 minutes or whatever, well, it may take longer than that. You see how long we've been out dealing with this issue. So that's what I mean by forewarned judge is a happy judge. So if we could take it up and I don't have to either have them sit in their headquarters, it's better for all of you.
I do not dispute anything you're saying, Your Honor. All I'm doing is suggesting that if last night or yesterday we were told tomorrow we plan on playing this call and it wasn't the chicken call or the whatever call, it's whatever the number is in the discovery or on the email, then we would certainly, I would say it would be on us. But that's not exactly what happened. I just want Your Honor, and I'm not trying to, I really like Ms. Hilton a lot, so I'm not even trying to argue with her or say she's done anything wrong. It's just, I think if we know a little bit in advance, and it's just, the chicken call, then we would be in a better position to lodge our objections to you. Because right now they are, I assume they're getting the cross-reference numbers, so then I can bring those numbers to the defense table so we can pull up the exact calls that they want us to review. So that's kind of, I just wanted Your Honor to understand it's not as simple as just we didn't listen to the chicken call.
Your Honor, if I may respond briefly, Mr. Williams, I believe, filed a motion in limine number 40. That was the only motion in limine that we had as it related to a jail call. And that was objecting to the third party information contained in jail call number 175 Charlie Alpha. Again, that Mr. Steele introduced by playing the interview of that Detective Quinn conducted with Adrian B. So we have again turned over the 8. We can specifically give track 1, 2, 3, 4, or 5 of CD 1, 2, or 3. We can give that information to them. The way that Ms. Hilton and Atkins noted and time hacked each of these calls references specific information in the call. That is the only reason Ms. Hilton identified it as such. But there were 8 calls. There's no other call within which the information she has spoken to the court and described the call using. There's no other call that has that information out of the only 8. So I'm not certain the reason for the reference to thousands of jail calls in this particular context. But, Your Honor, we have 8 jail calls here. We turned over. We've asked, what do you object to? And the only thing that we've gotten was motion limited number 40 from Defendant Williams.
All right. Anything else before we recess? I still gotta allow you to listen to the phone calls.
The facts got lost. The accurate facts, I listened to all the calls, the relevant calls. I've listened to them all. I know what the chicken call is. I know what the baseball call is. The issue is there's third parties making statements of fact, introducing statement of fact. We argued this. The state's position was it's non-hearsay because it goes to the effect of Mr. Bean, who will be a witness. I dispute that. I believe it's hearsay. That was the issue. You said, well, take it up.
Sure.
That's it. I'm not saying I don't understand the parameters. The only call that had the issue is Madam President, District Attorney Hilton said, I don't remember what the third call is. I'll let you know on a break. I was comfortable with that. But I just want you, before these jail calls are being played, to make a ruling, because I waive it.
I need
Whether it's
to
hearsay or
hear the
not.
call though.
Exactly.
Okay.
That was my objection. That was it. And I did it in a manner that I thought was appropriate to say that we raised it. Your Honorable Court told me to let you know. And then we got here.
All right. All right, N105? Okay, all right, they're both denied. I'll note your objection and the continuing objection, Mr. Harvey. All right, we're gonna take, did you have something, sir? Okay, we're gonna take 15 minutes so you can listen to the call, and we'll come back at that point in time, okay? All right, we're in recess.
They're in recess for 15 minutes. Then in recess for 15 minutes. Okay, we're gonna find a third one. I hope everyone is having a blessed day. They is in resume. They gonna resume. I guess they're getting the other lawyers a chance to read up on the emails that they got sent to them. But that trial is a mess. That trial is a mess. And
Do you remember a detective telling you in September
all right, we gotta go back. Hold on. As I was saying, it's a lot of mixed feelings in the chat. Most of them, they want him free, but evidence is evidence. It's what you can prove in court. The judge, he is so frustrated with both sides. As continue to read some of they saying on here. They telling the judge he got to go. Said like still said it, judge get loud with state is always with jury. So they agreeing with on the defense side, most of them, judge and little texting out. See, does he say that's allegedly? And then some say they wish the judge conduct a fair trial. Once I surprised still actually said what we doing. Mr. Steele stands up for himself. Really made my day. High wings. The whole world see the body still did that. Line me up. Trey Fax's bias. Still for president. Free thug. $3 million. Even Ice Spice has $5 million. Secure your energy mind to by the time they come back, how about we call it a day? Group chat. All right, they're going into group chats and still it's the man of steel faster than Monday. The third I love, Brian. Pete, what's your thought? Oh yeah, I've been blocked from folks. Shut up, Miss Steele. Not only does this affect the defendants on trial, is held for they're just sitting in jail waiting for a bond hearing. The entire jurisdiction, mine took. That's rude. Low IQ chat can't see the fat forest for the trees. Come on, MSC. What happened to the feed? Still couldn't take the disrespect. Miss Love, shut up. the world sees the by action. Thug should have had a bun. He ain't killed anyone. So it go on and on and on and on. They keep calling the judge biased. They say he a threat to society. A different judge would give him a bond. I never seen a judge who can leap a crack house in a single bond. He should be out on house arrest, bare minimum. See, most of them are on his side. DA probably called the news to interrupt this. This trial will last until 2027. He screamed at the too. I know that for a fact. And right, this is a group chat thing right here. It said long grand trial.
Ease of doing business, low prices, and
Now you can't grasp simple concepts. The judge is to maintain the equity of the court, which he himself is jeopardizing. About me, I live it. Yes, a new trial is definitely in order.
week only, get all Domino's menu price pizzas for 50% off when you
Each dog is incredibly unique. Feed your dog's unique needs with Royal Canin Precise Nutrition.
They is on a break. They be coming back shortly. You watching Jeffrey Williams, aka Young Thug trial, Rico trial. They in, but they ain't turned on the mics yet. So play some gospel while they on break. Well, at 1 hour.
used to be a pepper lady. Cinnamon. And he made everything alright. I stepped down just in time. She made everything fine. That's why I put my
Trust in Jesus. Trust in Jesus. Put my trust in Jesus. Need everything. Wow. Trust in Jesus. Trust in Jesus. Put my trust in Jesus. Trust in Jesus. Put my trust in Jesus. Made everything all right. Trust in Jesus. Trust in Jesus. Trust in Jesus. Made everything all right. Just no. Trust in Jesus. Put my 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 trust in Jesus. I put my trust in Jesus. My put trust put my trust in Jesus. Put my trust in Jesus. Put my trust in Jesus. With everything right.
Want luxury hair repair that doesn't cost $50?
No, no, no. Yes, sir. 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 Righteous. Yes, sir. Yes, sir. Yeah.
There you go, Pooh. Join on in.
Victory. Many people down. I can't live without. That is why I love him so. Jesus real to me. Yeah, real. Jesus is real to me. Oh, yes. It gives me the victory. So many people down. I can't live without him.
Objection.
Yes, please. This is in respect to states 175 Delta.
Yes, Your Honor. I'm want to share and play the call.
Excuse me.
No. But Your Honor, I believe Mr. Steele has an objection to a portion of 175C Charlie.
So
Charlie Delta, I'm
from
sorry.
your discussion, is it Charlie Delta or Charlie?
Charlie, 175 Charlie.
All right, what is it? Is it Charlie
Charlie.
Delta?
The
What is
first objection he has is to Charlie.
Okay, and how long is Charlie?
The entire call is about 15 minutes, but
Okay, and what specifically is Mr. Steele objecting to?
the portion of the call is time stamped 10:35 through 10:56.
Okay,
And the state intends to play that.
that's the portion that he has a specific objection as to.
Yes, Your Honor.
Okay, all right, let's play that first.
And do you mind if I sit, Your Honor?
No, not at all. Mr. Steele, is that correct? States Charlie, 10:35 to 10:56?
That is correct. The state said they're playing from 000 through 125. I do not oppose the state, assuming the foundation can be laid. State then wants to play 1039 to 1330, but I do oppose the objection. I believe it starts at 1035 through 1056.
Okay,
That is correct.
all right. Let's play it. Let me hear it.
Hello, prepaid. And Your Honor, I'm gonna start from the 1039 to 1330 portion. Well, Your Honor, I'm gonna start at 1031.
Yeah, what it is?
Yeah, but todo también ahorita bola 150 dollars. He probably that was lean. Y'all just say y'all didn't get lean for one way. Oh, so there's so much going on. I don't know what he has. I just don't know what he has. Yeah, y'all was playing.
Plus, she's got to check on it. They call charges and they call all this shit. They call jail check sheet. Cause them niggas out there, you know, stole all type of shit. And I don't even know what our brother got. Well, you don't even know what that nigga buck boy had. I ain't give him that. I know I'm gonna let my
They said about they told the whole story, goddamn book for LIL. I'm saying they don't hold to everything.
Whoa.
Now they were going. There was too long to be sitting down with y'all last. Who went on the home? Now we went grocery shopping. He gonna come back and cook the chicken and I thought shit like really bitch. Oh my God! Then they went to look for that boy. I mean, the whole story. The whole fucking story, like, you what you do, this your family over here?
Who?
Like, you don't do that, you. You know the cook chicken.
I'm fucking with them. I told them I know how to cook the chicken, but I told them on the rip that Buck and them gonna go there cook their own food. Buck know how to cook. Buck gonna go to the Blue and cook their food. I want them to cook them a goddamn thing. That was Buck told us they were gonna cook the food, then they like,
yeah, you supposed to come back and fried chicken and all this shit.
Look at my cup, they've already had 8 things on. Don't even pop that. I ate some Mickey D's. Them folks down there, somebody were hungry with store. That girl from Sheriff from food stamp. They come out going to the store. I told them to go ahead and go to the store. They went to the store. They come back. Come on, goddamn, it's a leak around the corner. Goddamn, that nigga ain't got that red. Man, got some money. So I said, shit, get the skateboard car then. Goddamn, y'all take skateboard car. Then they know, I like, fuck that shit. The nigga told me about $15,000, $40,000. I like, fuck that shit. I'm finna get the car and drive. That was it. That's the only time I drove all yesterday. I didn't go nowhere. I ain't been no grocery shopping. No motherfucking place. I don't know what the fuck they do. He was just face shit anyway. They don't know what they don't know what they can't be lying like a ball. Who would even make up something like that? I ain't even had no shit like that. I ain't no y'all. I sell food. When I go in there and let somebody get something to eat, I be fucked. Go out there and cook your own food. Rick, go out there and cook your own food. Whoever working, go out there and cook your own food. Hey, y'all cook your own food. I'm not going to there cooking that for nobody, man.
Yeah, so we got there yesterday when they showed up. Your mom came cut the goddamn lights off her phone. So, but they still around there, like, literally today, they still around all day, like, I said, well, you need to go put them folks out their house. You need to go put them out there.
Yeah, I'm sorry. We went past the 13.
Obviously.
I apologize. So, Your Honor.
All right, who is speaking in States 175 Charlie?
Sure, Your Honor. The two callers, well, the caller is Adrian Bean, and he's speaking with his wife, Courtney Bean. The portion in which Mr. Steele objected to is the portion from 1035 to 1056. Specifically, I'll just replay that particular portion so you can hear that. All right. And I'm going to start it at 1031 and I'll stop it at 1056.
It is what it is.
Yeah. Like, he said, well, what I had to see about it, he bought lean with her to pick up what lean, and y'all didn't say y'all didn't get lean, so what's that? Oh, God, there's so much going on, I don't know what he had, I just don't know what he had. Yeah, y'all didn't play.
And I think that ends the portion on which Mr. Steele is objecting to.
Okay, Mr. Steele, what's your basis, sir?
Your Honor, it is a third party speaking. I believe the voice is Courtney Bean. That is my belief. And she is saying outside of the court, it's being introduced for the truth of the matter asserted, that Jeffrey Williams, known as Thug in that call, said that they was worried about the lien, was getting the lien. I cannot confront or cross-examine Courtney Bean. Therefore, as I did previously in writing, it's a third party. Is non-testifying third party.
Is Ms. Bean coming to testify?
No, Your Honor, she's not.
Okay. Is she otherwise not available, or is she unamenable from appearing in court, or is she deceased, or what?
No, Your Honor. The state believes that this portion can be called because Mr. Steele implaned both the interview with Adrian Bean as well as the jail call, the second jail call with Adrian Bean, which they talk about this lien conversation. It derived from these jail calls. So when you heard the interview in which Detective Quinn is talking about the lien, or they're talking about the lien within that interview that was introduced by defense counsel, they've opened the door for us to give context with this call as to what they're talking about.
So you're saying it's not for the truth of the matter asserted?
It is not being offered for truth in the matter asserted in this case. And this whole conversation about the lien has already been introduced. This is what was introduced through that entire interview. So this is not being offered for truth in the matter asserted.
What was that exhibit?
I believe that was one.
Ben Williams.
It was the Stacy exhibit 176C, 175C Charlie.
Okay.
But we did not object to Mr. Steele introducing that entire recording, but Mr. Steele's the one who introduced it.
Okay. So 175 Charlie's already been introduced, and
Yes.
it already has this portion of the tape in it.
Yes, they're talking about the lien and all of that. Yes, it's already before the
Okay.
I don't believe. May I have a second? Yes, sir.
No, sorry, not the jail call, just the context of the conversation. Excuse me. So let me be clear. Not the jail call. This jail call is not introduced, but the context of the lien conversation is already introduced. And we're not offering this for the truth of the matter asserted. This is giving context to all of that conversation that they were having within that interview with that Adrian Bean and Detective Quinn, that interview that they were having.
May I respond?
Yeah, sure.
Mr. Bean is interviewed by Detective Quinn. It's 176 state exhibit. And if I'm wrong, it's 156, I believe, state exhibit.
The interview?
Yeah.
175.
Sorry, 175. This call is not played to my memory. It may be referenced, but Adrian Bean tells Detective Quinn that he was buying lean and he was robbed. You don't need to complete the story a third-party statement about lean. In fact, in these jail calls, Mr. Bean again says, I was buying lean. So the state is introducing now from a third-party non-testifying Thug. Thug is interested in the lien or worried about the lien. That I cannot confront. That is an out-of-court statement, and it is offered for the truth of the matter asserted. And there's other evidence. It is not, I didn't open the door to this call. It was already in evidence that Mr. Bean said to Detective Quinn himself, he was there to purchase lean.
Okay. Ms. Hilton, Ms. Love, is Courtney Bean is Mr. Bean's spouse, correct?
Yes, Your Honor.
All right, and she's not going to testify?
She is not testifying.
Okay. If she's not going to testify, go ahead, I'm sorry.
I'm gonna say additionally, Your Honor, a few things. In addition to it bringing context, it's also effect on the listener, as well as I want to cite the court to Jones v.
Which listener?
Adrian Bean, because he's commenting on what his wife is telling him in this case. And I want to direct the court to Jones v. State, which is 339 Georgia at 95.
95?
Sure, it's 339.
Is it 95?
339 Georgia,
Okay.
Georgia at 95. It's a 2016 case. And I'm looking at LexisNexis, Your Honor. It's going to be at Penn site 101.
Okay, so, yeah. Oh, you said it's a one-on-one.
Penn site 101.
Went to 1 hour and 28 minutes, 26 minutes. Ooh. Sun is hitting me.
I understand what Jones is saying, but I think Mr. Steele is saying, well, look, they're referring to his client, and he and his wife have basically inserted his client in this particular conversation.
So that's exactly what's happening in Jones v. State. So the informant.
Different because it's in Jones, you got an informant and you got a drug sale. So those particular statements were made for the context of what a G was, a gram of heroin. So,
but the issue here in this case, Your Honor, was that they did not want the recording to come in the entirety of the phone call itself when the informant was not testifying. And Mr. Steele's argument is that because Courtney Bean is not testifying, therefore the call cannot be played. But in Jones, what Jones is saying is, although the informant was not called to testify, that recording could still be played. And it specifically says, in admitting the recording, the trial court ruled that the informant's statements were admissible to provide context for Jones' response.
what statements are you trying to place in context?
I'm placing in Bean's context. So remember, him and his wife are having a conversation. So things that Bean is saying on this call have to be placed in context so that the jurors understand why he's responding the way that he is responding. And that is why, based upon what his wife is telling him. So
what's he saying about Thug? Or that on this call? They're
talking about the lien and what was happening as a part of what happened on September 11, 2013. So so her conversation is all in reference to what happened on September 11th. Remember, at this point in time, Your Honor, Mr. Bean is in jail after being going to the hospital, has gone back to jail. So they're on the call right now discussing what happened on September 11, 2013. And this is after a number of calls. So, Your Honor, and to put it really in context, this is the third third call that happened after Stacy Exhibit 175 C that was entered into yesterday, as well as Defense Exhibit 205. And then this call is a part of those jail calls that all came in right between September 11th and September 12th and September 13th, Your Honor. And so all of these calls are talking specifically about what occurred on September 11th, 2013. And Mr. Steele, again, has already introduced what Thug said about the lien. All that came in during that first call that has the third party individual. So this information about Thug and the lien and all of that is already, one, in evidence because of the other call, but two, this is a jail call that is not part and parcel, but that came in after those two calls that we've already heard. So again, this is all putting those calls into context, Sean.
Okay, well, you'd agree. Jones is making the statements in this particular on the phone call to the informant, right? In Jones versus State.
Yes.
Okay, all right.
And
so,
in addition,
but Bean's making the statements. So, what theory, other than the fact of context, are they admissible? Because in Jones, the court goes on to say that as a result, Jones's statements, the court determined that they were admissible as admissions of a party opponent. So, if Bean's making the statements and he's making the statements about context, how are they admissible against Mr. Williams?
Again, Your Honor, because it's the context of what they're talking about. Mr. Steele has already a couple of things. One, it puts in the other calls that I just referenced. Two, Mr. Steele, through his cross-examination of Adrian Bean, has insinuated that Mr. Bean was lying about interjecting Mr. Williams into this incident.
Let's still hearsay.
But so this also would be a prior consistent statement because
prior consistent statement?
Adrian Bean, because when Mr. Steele was cross-examining him on the stand, he said, you only did this just to put Mr. Williams in it. Mr. Williams is just lying, all of these things. However, he had a jail recording call that was consistent with what he told Detective Quinn during his interview. So Adrian Bean's previous statement on a jail recording would be a consistent statement that he wasn't just trying to put Mr. Williams into this case just to put him in. He had already said that before his interview with Detective Quinn also. So it comes up for a number of different reasons, Your Honor, but it's a prior consistent statement. We do believe it also provides context. And so again,
the predicate under Jones is it provides context.
Right.
Then you have to have a separate admissibility theory or basis. And so you're saying it's a prior consistent statement.
Yes, Your Honor. And remember that, it was all the information that Detective Quinn made Adrian Bean lie. Detective Quinn wanted Thug into this case. Detective Bean was just putting Thug into the case just to put Thug into the case. Those types of questions came out on cross-examination, and this would be evidence of a prior consistent statement of Mr. Williams' involvement in this case prior to Mr. Bean ever being interviewed by Detective Quinn. And again, lastly, Your Honor, before I sit down, Mr. Steele said that Adrian lied, but to rebut that argument of recent fabrication, again, this would be a prior consistent statement.
Well, that's what a prior consistent statement does, is it rebuts prior fabrication.
Yes.
All right, Mr. Steele.
A prior consistent statement, it would be of Mr. Bean. I've only challenged Ms. Courtney Beans. This is not a prior consistent or inconsistent statement of Courtney Bean. She has not testified.
They're saying is of Mr. Bean, not his wife.
It can't be a prior consistent statement because Mr. Bean is the only one who testified. I challenge Courtney Bean's statement. I'm not challenging Mr. Bean's statement. He talks about lien in all these recordings and to Detective Quinn. I'm not challenging that. So prior consistent statement does not work respectfully. And that's also under Tomei, T-O-M-E, from the United States Supreme Court, Bogg, B-A-U-G-H, from the Georgia Supreme Court, Adams from the Georgia Supreme Court. And the improper motive has to be challenged, and the statement has to be before the improper motive. This is the improper motive already happened, and then these jail calls. But that's irrelevant because that would be Mr. Bean's statement. I've challenged Courtney Bean. In addition to that, I think that the state is still going back to, it puts things in context. We don't need any context. He's already talking, he being Mr. Bean's already talked about lien the whole time. So I think it is for the truth of the matter asserted. It's not, and it is not non-hearsay. And I ask the court to redact that portion.
Okay. Christina? Can you tell me when you recessed again?
Yeah, I have one response to that portion.
Hold on. Six. All right, Ms. Hilton, I'm back on the record, so what does he want to tell me? And I think Mr. Short had something he wanted to say.
Well, we just want to add that his acquiescence about what the.
You have to speak up.
That Mr. Bean's responses to what Ms. Courtney Bean said would be an adoptive admission to his co-conspirator, which would have been Mr. Williams in this particular incident, Your Honor.
How's an adoptive admission? An adoptive admission is something along the lines of, I say that, you know, you're a child molester and you don't deny it. Or something that you would ordinarily deny.
I'm pretty sure adoptive admission went out in January 1, 2013, but I will check.
I believe it did. But could you check, please?
Yeah, I'm looking at Carlson's, the 8th edition, and I'll look again.
Guys, still here. So part of the OCGA section 24-8-801 E
D2B.
B is the barrier.
D2B?
C, yes. It's still there.
Do you have any argument, or do you have any further argument as to whether that is an adopted admission?
Yes.
Okay.
This is not adopted. It's not adopted by anyone. It's an admission by a party opponent. Admissions shall not be excluded to the hearsay rule. An admission is a statement offered against the party in which a statement of which the party has manifested an adoption or belief in its truth. It's a lie. The lien deal is a lie. That's the whole point. I need Miss Bean here. She's attributing something to Mr. Williams, and the state is just arguing anything to try to get it in because I can't cross-examine. So it is hearsay, and it does not fall under an exception to the hearsay rule.
Just what Mr. Steele said. He's claiming that the lien deal is a lie. In this prior consistent statement, and that this is a lie that Agent Bean made up during his interview. Therefore, we are able to bring in the prior consistent statement of him and his wife talking about this lien deal prior to him allegedly making it up during his interview. If you look at the timeline, Your Honor, these calls have been between the 11th and the 16th. He meets with Detective Quinn on the 17th. So these calls are before the alleged recent fabrication. So just like Mr. Steele just said, he's arguing that Bean made that up to Detective Quinn. Well, no, this is evidence that Bean did not make this up. That in a conversation with him and his wife is talking about what happens out and he's responding back to her. So it's his effect on the listener. It's what he's responding to about what happened on September 11th. And again, these are conversations they were having in all of these jail calls between September 11th and September 16th, two of which had already been admitted.
Okay. All right, I'm gonna exclude 1035 to 1056. I believe it is, it's hearsay, so I'm gonna exclude it at this point. Okay, so we need to redact it. All right, folks, it's nearly 6 o'clock. I'm gonna just call our jurors back in. I want you all to redact it. I believe that we are going to be, tomorrow's gonna be an administrative day. I think I take up something. And then the 22nd, Friday, we'll come back at about 12:30 for a 1 o'clock start time. Mr. Sharp, just have a seat just a second, okay? All right, Mr. Steele, I'm gonna just, and for others, okay? This is exactly why the court tells everybody or has told everybody ad nauseum about preparation. We started back, we had a conversation about Mr. Steele's motion, and the court's response to it, but we recessed at 4:32. We came back at 5:23, and it's almost 6 o'clock at this point in time. That is exactly why the court asks all the parties to go ahead and see if you can resolve what you can resolve, or let me know so that we don't have a jury that's been parked back there for nearly 2 hours. That's why I'm kind of really incessant about us being prepared. Now, routinely, we also have, is there anything I need to take up for bringing the jury? I really don't want you all to, I do that as a matter of courtesy, but it seems like there's always something I got to take up. If we need to start coming an hour early so you all can exhaust all of those issues, we can start doing that. Because that's the challenge, and therein lies the challenge for the court. It's your jury, folks. You spent almost 10 months picking jury. Now, and I told you that the jury who gets a chance to kind of proceed through what's being heard is better and more content. So that's why, Mr. Steele, when I said you weren't prepared, it's not because I don't think that you are a worthy adversary or you're not representing Mr. Williams to your capability. I'm just stating that this is my concern. It is not directed to you personally as a unprepared lawyer. This is just an example of why, and I think I've kind of had everybody to task at some point in time on this particular issue. It's not my intent to make you feel any way other than just do better. That's all I'm asking everybody, just do better. And just let me know whether or not we need to kind of park in place and then go ahead, and we could have probably taken this up at another day or whatever else. I cannot believe that after the amount of time you'll have this case, that you haven't gone through some of the relevant things, because we've been on the same act for a period of time. And had we and even though you might have said, Mr. I don't have any reason to doubt you, didn't say, well, we need to take this up. It's just the timing and the preparation, and it could have been done a lot better. So to that extent, that's what I have. As to your motion, sir, you are welcome to file a motion to recuse me. I cannot prevent you from doing that. Certainly, if you do so, I'll deal with it accordingly. And I will deny your motion for mistrial. But that's kind of where we are at this point in time. I've told every lawyer in here, this is one of my concerns as a trial judge for many, many years. I've debriefed hundreds of juries. That's something I'm trying to give you the benefit of, is not stop and start. Let's just, streamline it as much as possible. So with that, I'm going to call our jurors in. I'm going to recess them until Friday at 12:30. And then you can take up whatever else you want to. Is there anything else? Okay. All right. Summon our jurors first, please. Sergeant Brown. Oh, I'm sorry. Before you do that, Mr. Sharp, anything?
Well, yes, sir. And I understood it that you can take up after the jury was dismissed, but I do now. I just want to put this on court's radar. I understand Mr. Steele's motion. I agree.
I also.
What motion?
I mean, the concerns about these recordings. I also,
Detective, can I get you to step out just for a second? Okay, please, sir.
yes, sir.
Thank you.
And
Hold on, wait one second.
yes, sir.
Okay, with the recordings, you left out of that.
Yes, Your Honor. And Mr. Steele just argued about Courtney Bean's statements. My argument is that Adrian Bean's statements on the jail recordings at this point are inadmissible. And Your Honor,
Talking about the rest of it, not just the excluded portion?
yes, all of Adrian Bean's, and this is why. There's the way I see it, there's two possible arguments, prior inconsistent statements. The state on other recordings laid the foundation for prior inconsistent statements.
Okay, but you've examined Mr. Bean, right?
But Your Honor, if you look at, that is correct, but.
And did you examine him about these particular
No, we did not. No, we did not.
Could you have done that while he had him on cross? Could you have done that while he had him on cross?
I absolutely could have.
Okay, all right.
But Your Honor, the rule is the proponent. It's 24-6-613 and as well as.
Well, we've already admitted the evidence, and that's you're talking about.
I'm not referring to the ones that were admitted. I'm referring to the other ones.
What are you referring to? Are you talking about Charlie? 175 Charlie, because that's what we're talking about right now.
Okay,
and
so
Mr. Steele has successfully argued for me to omit 1035 to 1056.
I'm referring.
So you're asking for the entirety of stage 175.
Not the one that's in evidence, but my understanding is we were talking about all three: Charlie Delta, and Charlie Echo.
The only one that there's an objection as to right now is Charlie.
Okay, I am objecting to Delta and Echo, and to Mr. Bean's statements as well. And if you look at 24-6-613, which is prior statements by witnesses, and it says, okay, excuse me, 24-8-801, D1C, a statement shall not be hearsay if the declarant testifies at the trial.
Which you did.
Or hearing, and is subject to cross-examination concerning the statement.
Which he was.
That's where I disagree, Your Honor. The state, in certain jail calls and in Detective Quinn's interview, the state and Miss Love, and I understood what she was doing at the time. She asked very specific questions and confronted Mr. Bean with things that were said. That was not done, in my opinion, for these additional cell phone calls. She did not say, did you say to your wife, Courtney Bean, on this date, yada, 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 and have him either say, I don't recall or deny. So I don't believe the foundation was laid for a prior inconsistent statement. Now, as far as prior consistent statement, which is Ms. Hilton's, what was her stated argument, if you look at the prior consistent statement statute, which is 24-6-613, it talks about in examining, it said, and it talks of consistency with the testimony. What in this case, the state, as it appears to me, they have a prior statement which has been admitted into evidence. And if you look at Cowart v. State 294, Georgia 333, and all the other cases they talk about to rehabilitate the testimony. There was no testimony. All we got on the stand from Mr. Bean was, I don't recall, I don't recall, I don't recall. They are trying to rehabilitate. They have a prior statement made by Mr. Bean, and they're saying prior to this prior statement, there's a motive for recent fabrication, so we want to go behind that. But I can't find any case law that suggests that you can rehabilitate a prior statement that was not testified to on the stand. So on the stand, we got nothing from Mr. Bean So I don't believe that there's anything to rehabilitate under the prior consistent statement statute, because all we got to understand, I think we probably all could agree, all we got to understand was, I don't recall, I don't remember, or I don't know. And while that is sufficient to lay the foundation at times for a prior inconsistent statement, if done correctly, in accordance with the rules, I can't find any authority to say that, in Coward, it says prior consistent statement of witness admissible only when witness was impeached by some affirmative charge that witness's testimony was tainted by recent fabrication, improper influence, or improper motive, and the prior statement predates the alleged fabrication. It talks about testimony. There's no testimony that was provided by Mr. Bean. There was just, I don't recall and I don't know. And I understand that they brought in prior statements he made, but if I read the statute correctly, the plain reading of the statute, and also I don't see any case law that would support the argument that they can rehabilitate a prior out-of-court statement with other prior out-of-court statements. And that's my argument.
Thank you, sir.
Thank you.
Ms. Love?
Thank you, Judge. 246613C says a prior consistent statement shall be admissible to rehabilitate a witness if the prior consistent statement logically rebuts an attack made on the witness's credibility. A general attack on the witness's credibility with evidence offered under section 246608 or 609 shall not permit rehabilitation under this subsection if a prior consistent statement is offered to rebut an express or implied charge against the witness of recent fabrication or improper influence or motive. The prior consistent statement shall have been made before the alleged recent fabrication or improper influence or motive arose. So as to the argument that it is not a prior consistent statement because Adrian Bean did not recall, it's not one that carries merit, because the statute specifically, and what Mr. Steele did specifically, was assert through his cross-examining questions that Mr. Bean was lying in the interview with Detective Quinn. That is the recent fabrication, that the prior jail call, the statements made in the jail calls prior to that are being offered to rebut against. That's as to the prior consistent statement. As to the prior inconsistent statement, Your Honor, what I did when asking Adrian Bean the questions that I asked was, did you ever at any time talk with your wife about the lien and the $50 and the $150? I asked specific questions that went to, when he said, I don't recall, I would not only ask him about what he said to Detective Quinn or what he said during a specific jail call, I would broaden it and say, did you at any time during this time from September 11th to September 16th talk with your wife about X, Y, and Z? So Mr. Shart's argument that the state did not properly lay a foundation for impeachment or for prior inconsistent statements to come in is meritless, because the statute now and the case law now does not require that you, with the level of specificity as to a date and time, meet him with all of those. I asked him specifically about jail calls that he made with his wife, and specifically asked him, did you ever at any time speak with your wife about X, Y, and Z? Do you recall any conversations you had with your wife while you were in the Fulton County Jail? So the argument that Mr. Shart makes that they are not prior that certain statements that we're arguing are prior inconsistent statements, and that we are not able to impeach Adrian Bean's trial testimony inaccurate, because I laid the foundation for the admission of all of the statements that we're attempting to put in through the jail calls that he made.
All right.
Briefly, under 246613 says, extrinsic evidence of prior inconsistent statement by a witness shall not be admissible. And I think we can agree that this would be extrinsic evidence. Shall not be admissible unless the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposing and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or in the interest of justice.
So you didn't avail yourself of that during cross-examination, Mr. Shaw?
Well, but
Answer my question.
I can agree with that, but I can agree with that, but the witness himself, the state is essentially saying that we can lay the foundation by saying, did you ever say this? Did you ever say that? And what I'm saying is on the statute, it says, is first afforded an opportunity to explain or deny the prior inconsistent statement. It's still, the statute itself is anticipating that he's going to be confronted with the statement, not just with a broad, have you ever said this in your life, with the statement. And so I am arguing that state, and I'm aware of the law and what's required, and they don't need to say the date or time, but I don't believe that just saying, have you ever said this, is sufficient to confront him with that statement. And that's my argument.
And Your Honor, I did not say ever in your life. I said, did you, while you were at the jail during this time frame, did you speak with your wife about lien? Did you ever talk with her while you were in jail from this time to this time about the lien, $50, $150?
All right. Okay. All right. So based upon your arguments in the cases you cited, and the court's consideration, I'm going to admit states 175 Alpha Bravo Charlie subject to a redaction. Charlie subject to a redaction of 1035 through 1056. I'm going to admit states 175 Delta and Echo.
And Your Honor, those are Charlie Alpha, Charlie Bravo, Charlie Delta, and Charlie Echo. So there's a C.
Why do y'all make things so difficult?
I know.
All right. So state those again, Ms. Love.
State's Exhibit 175.
The ones that you're offering for the purposes of this particular.
Yes.
It's State's Exhibit 175 Charlie Alpha.
Charlie Alpha. Hold on. Charlie Alpha.
Charlie Bravo.
Charlie Bravo.
Charlie. Charlie Delta.
Okay.
And Charlie Echo. But Mr. Steele has an objection to a portion of Charlie Echo that we just haven't addressed yet. We can address that on Friday.
All right, so you all so we've dealt with Charlie,
yes,
that particular portion.
Yes.
All right.
So I believe the only other objection is the Charlie Echo, and we can discuss that on Friday. Or at the court's pleasure.
Excuse me.
Anybody that's gonna watch the replay, watch. I appreciate it. I love each and every last one of y'all. I'm gonna close this live. Y'all have a blessed day.